Tonight, multiple lawsuits slap the office of the Attorney General less than 24 hours after President John Dramani Mahama triggered processes calling for the removal of Chief Justice Gertrude Torkornoo, with the plaintiffs citing breach of the Constitution and abuse of the CJ's right to hearing. We have details as the woman at the center of the controversy. Justice Torkornoo writes to the President demanding to be furnished with copies of the petitions against her removal. We'll hear from the former Deputy Attorney General, Alfred Tuah, who insists the President must not proceed on the matter without hearing from the Chief Justice.
For the court to read into the provisions in 148 that the Chief Justice, being a judge for that matter, is also entitled to have that provision relating to prima facie determination.
We have details of all of the suit filed against the Attorney General. We have the letter from the Office of the Chief Justice to the President. All of that here, plus reactions from people who really understand the law. On Top Story, brought to you by Telecel, connecting energies and holy insecticide spray and coil. Enjoy a holy sleep. Well, tonight, the Attorney General has been slapped with two separate lawsuits less than 24 hours after President John Dramani Mahama triggered processes calling for the removal of Chief Justice Gertrude Arabasaki Torkornoo. Now, President John Dramani Mahama last night referred three separate petitions calling for the removal of Chief Justice to the Council of State for advice. Just today, two citizens, Member of Parliament for Old Tafo, Vincent Eko Asefua, and private citizen Ebenezer Osei-Owusu, have filed separate cases at the Supreme Court asking for an interpretation of Article 146 of the Constitution and to determine whether or not the President's decision to forward the petition to the Council of State without first hearing from the CJ is unconstitutional. We will be getting such education, on this particular matter shortly. But first, my colleague Kweku Asante joins me with details of the suit that we do have. Kweku is a member of our legal affairs desk, and he's been pouring through the suit that have come in against the Attorney General in this particular matter. We'll be bringing us all the details. Remember, the former Deputy Attorney General has been speaking on this particular matter. But let me bring in Kweku Asante now. Kweku, let's start with the case filed by the Otafo MP, Vincent Eko Asefua. What reliefs is he seeking? Okay, so we'll try and reconnect with Kweku to understand exactly what the reliefs are. Again, we'll bring you that letter that the Chief Justice herself has written to the President on the matter, asking for her to be furnished with the details of these three petitions. Would find out why he said that. Kweku Asante is joining us shortly with the suit. But a while ago, former Deputy Attorney General Alfred Tuah has been speaking to my colleague MFA Adeti on the Pulse. He won't be joining us for some conversation, but in his initial thought, he believes that CJ must have been given some hearing before the President takes the action he took.
If you take a look at Article 146 of the Constitution, it deals with removal of Superior Court judges. And you have two categories of Superior Court judges, if I may put it that way. You have the Superior Court judge as a Superior Court judge, and on the other side, you have the Superior Court judge who is the Chief Justice. When it comes to removal of the Chief Justice, you must first and foremost know that she is a Superior Court judge. And so all the provisions relating to the removal of Superior Court judges apply to her. And that's the very reason why in particular matter you've heard about prima facie determination. Because if you read the original text of the Constitution, you do not find that provision really when it comes to the removal of the Chief Justice. But it took a citizen of the land to take the matter to the Supreme Court somewhere in 2005 for the court to read into the provisions in 148 that the Chief Justice, being a judge, for that matter, is also entitled to have that position leading to prima facie determination. And the JQ case, Supreme Court made it clear that the president will have to make the prima facie determination in consultation with the Council of State. I think when the president received this petition, he decided to forward it. I'm not part of the presidency to the Council of State. Now the question that's coming up is whether a prima facie determination can be made without notifying the person whose conduct in court is being questioned in the petition. So that's the essence of this particular suit that we all read. But looking at the Constitution, you want to say that there's no way putting the Constitution that the subject of the investigation should be notified. But what has been the practice? I mean, the current administration has been in office before. There are other administrations that have been in office. And I think we have to leave the Supreme Court to determine whether, upon the careful reading of Article 146 and other legal provisions, especially Article 23, 296, and 7 of the Constitution, before the president can consult the Council of State to make that prima facie determination, the CJ ought to be notified.
Okay. Again, some education here. Until a prima facie is determined, what then will the Supreme Court judge or the judge, what would he or she be responding to? Just the petition?
Two things. Notifying her that 3 petitions have been filed against you and that is being submitted to the Council of State for a determination of whether there's a prima facie case. And secondly, that from the principal point of view, also asking her to provide her comments relative to the petition that has been filed against her. And that's the crux of the case of the plaintiff that is going to determine.
So that's the former Deputy Attorney General there, Kweku Asante of our Legal Affairs Desk, is with me on the line now. Kweku, let's start with the case filed by the Otafo MP, Vincent Eko Asefua. Let's understand the reliefs that he's asking the court to give.
For Otafo, who has filed this action through his lawyers, Godfred Yeboah-Dame, the former Attorney General, is seeking of declaratory release. First, he wants a declaration that upon a true and proper interpretation of Articles 146 and the various subsections, the President is mandated to notify the Chief Justice about the petition for the removal of the Chief Justice and obtain his or her comments and responses to the content of such a petition before referring the petition to the Council of State or commencing the consultation process with the Council of State for the removal of the Chief Justice. That is one. He wants a declaration that a failure by the President to notify the Chief Justice and obtain his or her comments and responses to the petition triggering the removal of the Chief Justice and goes as well as the constitutional protection of the security of tenure of the Chief Justice, who is also a Justice of the Superior Court of Judicature, breaches the said constitutional provisions. Again, he says he wants a declaration that upon a true and proper interpretation of the Constitution, a failure by the President to notify the Chief Justice and obtain his or her comments and responses prior to the removal processes being commenced is an unjustified interference with the independence of the judiciary. And finally, a declaration that a failure by the President to notify the Chief Justice violates the Constitution and the fundamental right to a fair hearing contained in Articles 23 and 296 of the Constitution. Those are the 4 main reliefs that Vincent Eko Asefua is seeking through his lawyers, Godfred Yeboah-Dame in court.
Now, just a while ago, we've seen another suit. Tell us more from that suit as well.
Well, yes, this action has been filed also in the Supreme Court by a private citizen by name Ebenezer Osei-Owusu at a numbered house in Agbogba. He is seeking quite similar relief as the one being sought by the Member of Parliament for Otafo, when he represents himself in court. He says he wants a declaration that upon a true and proper interpretation of the Constitution, and he backs it again with the case of a J2 as the Attorney General, the determination of a prima facie case by the President of the Republic in consultation with the Council of State for the removal of the CJ cannot be made without first furnishing the CJ with a copy or copies of the petition seeking her removal and commentary. Again, he goes on to say that without this will violate the Chief Justice's right to a fair hearing, and to that extent, unconstitutional, null and void. He goes on to talk about the action that has been done by the presidency by the notice signed by Felix Ofusu-Kwakye, and wants the court to make an order setting aside the decision of the President of the Republic to consult with the Council of State without first hearing from Madam Gertrude Torkornoo. It's a number of release that is seeking, but the cracks of the release are the ones I've given you, similar to the ones filed by the Honorable Member of Parliament for Old Trafford.
I'm grateful to you for those details there, but it gets more intriguing because we've just cited a letter from the Chief Justice herself to the President on that particular matter, and my colleague James Aveji joins me in studio with details of that particular letter. James, what does that letter say?
Well, Prez, except is saying that, quote, as you are aware, and this is from the CJ to the President John Dramani Mahama, that as you are aware, when a petition for removal of a Superior Court judge under Article 1461 is forwarded to the Chief Justice, the first requirement of due process is for the CJ to bring the petition to the attention of the accused judge and to attain their response to the petition. This is the right afforded every citizen in justice delivery, and it is provided for in Article 146 procedures. In my time as Chief Justice, I have handled 5 such petitions for removal of Superior Court judges and heard from them before determining whether a prima facie case has been made against them to merit the setting up of the investigations committee provided for under Article 1464. And so, primarily, she's stating in this letter that she is also considered as a Superior Court judge. And so, the laid-on procedures, which says that the judge in question must be heard from before the determination of a prima facie case and then onward forwarding to the President, should be also observed
in
under
fact, James,
this issue.
If you look at the letter, she again says, and I quote verbatim, so respectively, in the case of the Chief Justice, please allow me to submit that it is the combination of the evidence in the petition and the response of the Chief Justice that provides the material for consultation between His Excellency, the President, and eminent members of the Council of State under Article 146.6. These two sources serve to guide whether a prima facie case has been established, such that a committee of inquiry should be set up under Article 146.7 to inquire into whether the Chief Justice may be removed from the office. This is the direction of the Supreme Court in the case of Eje versus Attorney General and Akwete 205-206.
Then she goes on and indicates that, or concluded that letter by saying, quote, I am hereby this letter humbly and respectfully asking His Excellency the President and eminent members of the Council of State of States, and this is in bold, to forward the petitions against me to me and allow me at least 7 days after receipt of same to provide my response to you, which response can then form part of the material that you conduct the consultations anticipated under Article 146.6 before the possible setting up of a committee of inquiry under Article 147. So, what is interesting there is that the petition against me be forwarded to me for my response before any further action is taken.
So, her case is about,
she must be considered a Superior Court judge, and so the laid-down procedures against the determination of a prima facie case and then the removal of a Superior Court judge.
And what they call in law the natural justice, that that term says audi alteram partem, listen to the other side. So that's what she is looking for.
Exactly, calling for.
Should be.
Again, there's some reaction coming in from lawyer Tadiosori, also a senior member at the bench. 4 key quotes I'll give you from his writing. It says,
I'll come to you, but
okay.
We have on the line now lawyer Samuel Okujoto. He used to be the former chairman of the Council of State. I'm grateful to you, sir, for joining us here. Now, you've been at the Council of State before, and you are a lawyer too, so you can give us this education. When the petition gets to the president, what that should the president really do?
Well, first of all, you say I'm chairman. I was not chairman of the Council of State. I was the chairman of the Legal, Constitutional, and Petitions Committee of the Council of State.
Thanks for the correction, sir. Yeah.
And so, if there is any issue in relation to what you are discussing right now, it directly involves the position that I did occupy.
Yes, so I mean this is a legal matter, and because you've been there before, you can rightly educate us, and that's what I wanted to find out from you. When such petitions get to the president, what must the president do?
The president ought to be able to inform he must inform the Chief Justice and get the Chief Justice's reaction. It is that reaction together with the petition that he consults with the Council of State. And therefore, whether there is a prima facie case made or not, they will decide together. And let me also say that I have had an experience of that where a petition was sent, and that petition was accompanied by a huge volume of documents, that the Chief Justice's reaction. And that formed the basis for which we, as a committee and the council, took a decision that the petition was frivolous.
So,
because no prima facie case was made.
Okay. Because when you consulted a CJ, you realized that there was no prima facie case?
We did not consult with the CJ. Let's get it clear. I said she responded with a voluminous documents and explanations and procedures and processes that the petitioner completely is ignorant about. And that formed the basis for us to come to the conclusion that no prima facie case has been made.
When you read the Constitution for the layperson, it doesn't come across as though she has to be given that hearing before. But she's also writing that per the rule of natural justice, she had to be heard. So in this case, now that the petition has been forwarded to the Council of State, what happens then?
The Council cannot consider that petition without hearing from the Chief Justice. Upon what will be the basis for their decision? If they make allegation against the person, you didn't hear from the person, what will be the basis for your conclusion that you reach as whether a prima facie case has been made or not? It's simple logic.
Now, we know that when the president really gets this petition, in consultation of the Council of State, must appoint a committee consisting of 2 justices.
No, you are getting it wrong. You are getting it wrong. It is only when the president and the council has come to the conclusion that there was a prima facie case that they can refer it.
Okay. So it means that CJ has a point that she has to be heard before.
She's right, because I was telling you that we have done it before. The president there.
Okay. Interesting. So now that the case, there's been 2 suits filed at the Supreme Court against the AG on this particular matter. She is the one who has to then appoint justices to sit on this matter, right?
But they knew it. They know that is her right.
So
the Constitution does not give that power to anybody else. That's the more reason why sometimes we should be a little careful. And let me also just emphasize that this thing should not have been publicized.
Okay.
That when I was on the Council of State, we felt that it was a wrong thing to do. That when a petition of that nature comes to the president and sent to the Council of State, it should not have been publicized.
Okay.
It is only when the council and the president come to the conclusion that a prima facie case has been made that publicity can be given to it. I think it's a wrong approach.
So will the president and the Council of State be acting illegally if they should proceed without listening, without, doing according what she's asking for? That she's asking to be finished with the petition.
No. This is. I'm saying that it's not only law; it's also simple common sense. Is to say that on what basis is the Council of State and the President going to say that a prima facie has been made when they have not heard from the person who is accused?
Grateful. Stay with me. Let me bring in another lawyer, Professor Kojo Appiah. He is Associate Professor, School of Law, University of Ghana, and a human rights lawyer. Grateful for joining us. Now, the Chief Justice says, I have to be heard in this matter, even before the President determines a prima facie case. Is she right?
Well, we have to look at thanks for having me in the first place. We have to look at the issue from the constitutional angle. If you look at the Constitution carefully, Article 466 says that the President shall refer such a petition to the Council of States for consultation. And then, based on the decision or the advice of the Council of State, a committee will be set up. So, but if you look at the process for other justices of the Supreme Court, it says the matter will refer to the Chief Justice, and based on a prima facie conclusion, then the Chief Justice will go ahead and set up a committee. So you can see that the two processes are different on the face of it. So if there's a need for a prima facie case, then it means that the other party should be heard before a prima facie conclusion can come to. Then the committee will go into the matter full time in the fullness of it. But with respect to the Chief Justice, 1466 is saying that after the consultation, a committee will be set up. So you see the omission of prima facie case. So there can be two ways of looking at it. One is that it means that it doesn't completely deprive the Chief Justice of the opportunity to be heard in this case. But it is only at the stage where the committee is set up that the Chief Justice will have that opportunity. So the rules of natural justice is not completely denied the Chief Justice in this case. On the other hand, the interpretation that the Chief Justice herself and those petitions that have been cases that have been brought to the Supreme Court asking for injunction is that the prima facie option should also be given the Chief Justice, so that the Chief Justice will have the opportunity to know what the petition contains and respond to that, and that should go to the Council of State to make its decision. But the rules, the Constitution itself is not clear. The same thing applies with regard to the appointment of the Chief Justice. The rules are different from the Chief Justice as regards to the other justices of the Supreme Court. So I think probably in the view of the framers of the Constitution, they wanted to set up different conditions for the Chief Justice and the other justices of the Supreme Court. But if you look at the rules of natural justice, the Chief Justice may be right in demanding it at this stage before it goes to the Council of State, but it doesn't completely deprive her of the opportunity to have her case heard at the committee level. Or at the committee that will be set up in case the Council of State concludes that a prima facie the case should be referred to the committee.
Now she says, and I quote, respectively, in the case of the Chief Justice, please allow me to submit that it is the combination of the evidence in the petition and the response of the Chief Justice that provides the material for consultation between His Excellency the President and the eminent members of the Council of State under Article 1466. These two sources serve to guide whether a prima facie case has been established, such that a committee of inquiry should be set up under Article 146 to inquire into whether the Chief Justice should be removed from office. That's a case. Now you need to listen to me and add it to the consultation you will have before you can establish. Those two would help you establish whether there's even a case in it after all.
That's what I'm saying. That in this case, if you read the Constitution carefully, 1466 does not talk about prima facie case being established before the matter will go to the Council of State. So reading the black and white letter of the Constitution clearly does not give that provision or make that provision available to the Chief Justice.
But then she cites the Ejechin versus Attorney General and Akwete 205 says that what she said is the direction the Supreme Court gave in that particular case. That's her reference.
Yes, and in that case, I'm not sure it directly touches on the Chief Justice, but I could be wrong. But I think it's referring to justices of the Supreme Court. So that is where the prima facie case comes in, and that is the same argument she's also making, that she should also be considered as she's a part of or a member of the Supreme Court, and so that same rule should apply to her. And in law, there can be the situation where you say that there could be an omission in one part of the law, but if you look at another part of the law, it can be used to cover that omission. And I think that's the argument that the Chief Justice is making. So in that case, she's saying that let's take things slowly. Let the rules of natural justice apply, and let us see what the response will be. But we may also want to refer to the petition by Professor Asare last year that the Chief Justice should be removed. I don't recollect the facts very well, but in that case, the then President Akufo-Addo dismissed the petition. But we didn't see a situation where there was a call for a prima facie case, and the matter died a natural death.
Okay.
So, looking at the steps that President Akufo-Addo took, it means that there was no call for a prima facie case when the petition was brought before the President.
Okay. All right.
Yes.
I'm grateful to you, sir. Professor Kojo Appiah there. Let me bring in Samuel Kojo to again. So, how do you expect the Council of State to proceed moving forward?
Well, I've just explained to you that I disagree with the professor because his interpretation to me makes no legal sense. Why would there be a provision that protects judges or superior courts which does not protect the Chief Justice? And I'm telling you that even your conclusion about Akufo-Addo issue is also incomplete.
Okay.
I was the man and I wrote that opinion. And I am saying that between us and the President, we came to the conclusion that no prima facie case was made. Therefore, we dismissed the petition. As President, of which I was involved, I was the one who wrote it. And I'm saying that it is just simple common sense in legal interpretation. That you say that if something can apply to this, the same thing should apply to something else.
All right.
The Chief Justice is not occupying an inferior position to judges of the Court of Appeal
Okay.
or the Supreme Court. She does not. She is also a Supreme Court judge, and at the same time, the Chief Justice. So, a more rigorous application of the rules must apply to her. And so, you cannot say that because there was no provision in the Constitution. Constitution has to be interpreted in its broader context. It is not just words that we interpret Constitution. When you want to interpret the Constitution, you must take it and say, what is the intention behind what is written in the Constitution? That is the way to interpret it. You don't just take words.
Okay. All right. I'm grateful to you, sir, for joining us with this education. Let me go back to Parliament and bring in our legal affairs correspondent, Kweku Asante. We understand that a date has been set for the hearing of the injunction application against the processors to remove the Chief Justice. Kweku, what more do we know?
Yes, Brace, the process is moving quite expeditiously. We know that the action filed by lawyers for a conviction, as it was led by Godfrey Dame, was filed at the Supreme Court registry at about 9:35 a.m. this morning. We understand the Supreme Court will now hear the action the next available day, which will be Wednesday, 2nd April at 9 o'clock a.m. The Supreme Court will hear the injunction application that has been filed by Vincent Akosef, who are seeking to injunct the process for moving ahead for the Chief Justice to be removed, the process leading to the removal of the Chief Justice. He has filed for an injunction application And now the court is set to hear that application on Wednesday, 2nd April at 9 o'clock a.m. Brace.
Okay, very interesting days we have ahead of us here in Ghana. This has been Top Story, brought to you always by Telecel, connecting energies and holy insecticide spray and coil. We say enjoy a holy sleep. My name is Samuel Kojo Brace. Now we'll take a break and then we're wrapping up a Top Story, but when we return from the breaks, we'll take you to television where we are having a national dialogue on the back of the budget. Winston Amoa and his team of experts will be breaking down the budget for you to really appreciate what the budget is all about and what is in it for you. Good evening.